Since their hearts have been purified, they see with a clear seeing. Since they have great fear of Allah, it is not possible for them to be motivated by self-interest or personal greed, since they know this would take them to the fire. Further, since their self has been obliterated in Allah, it follows that there is no self to be interested in. Or rather, they see that the whole of existence is their self, so that personal greed is an impossibility. The Awliya of Allah are the complete antithesis of the kafir legal experts, who are not in a position to judge anything because they do not see anything as it really is. The charter, which was drawn up principally by American and English legal experts, and which defined how the Nuremberg trials were to be conducted, was framed in such a manner that it ensured that the desired end result of the trials would be achieved with ease. The official legal definitions of what was to constitute a crime, and the ways in which the commission of that crime was be capable of being proved, were so wide and so favored the prosecution lawyers, that even a child could have convicted the accused of the crimes with which they were charged. It must be emphasized that the accused were not tried in accordance with the rules and laws of any existing legal system, since this would have made the task of convicting them all far more difficult, and much more time-consuming and expensive. Instead, the Freemasonic legal experts created a legal system just for the purpose of the Nuremberg trials, with its own special rules of procedure and evidence, and with its own special definitions of the crimes with which the accused were charged. Had the accused been given any right of appeal to, for example, the English Court of Appeal or the House of Lords, the manner in which the Nuremberg trials were conducted would have been easily proved to be what existing legal systems would have defined as a gross irregularity in the conduct of those trials, and accordingly, the accused would all have had to be acquitted and their convictions quashed. It was in order to escape this possibility that a separate self-contained legal system, without any rights of appeal, was created specifically for the purposes of the Nuremberg trials. There were 4 major crimes of which most of re-accused were charged with committing. The definitions of these crimes were so vague and so all-embracing that a great many acts of war, which are inevitably committed by all concerned on both sides during the course of war, because that is the nature of war, could easily be shown to come within the ambit of these definitions, whenever it was convenient or expedient so to do. The 4 major crimes were crimes against humanity, war crimes, crimes against peace, and conspiracy to commit these crimes. It should be pointed out that since it was the Freemasons who had engineered the war in the first place, it follows that they were just as guilty of these crimes as the accused, if not more so. The charter also stated that it was a crime to belong to a criminal organization. The charter defined nearly all the organs of government and administration, and all the armed forces of Germany, and its official and secret police forces and intelligence agencies, as being criminal organizations. Naturally, their counterparts among the Western Allies were not regarded as criminal organizations, despite the fact that they had been operating in basically the same way and using basically the same methods as the Germans throughout the war. For ultimately, there is really no difference between one kafir and another, whether they be English, American, Russian, or German. Membership of one of these allegedly criminal organizations was defined as being prima facie evidence of the fact that the person concerned belonged to the conspiracy to commit the other major crimes defined by the charter. Since all the accused, and indeed more than half of the population of Germany, belonged to at least one of the bodies which were defined as being criminal organizations, it followed that they were all automatically implicated in the conspiracy to commit the other major crimes before the trials had even begun. All that had to be shown, once the trials had started, for the accused to be found guilty of the conspiracy charge, was membership of one of the what had been defined as criminal organizations. In effect, the Freemasons were accusing the German leaders of the very conspiracy in which they themselves were involved, and which Hitler had unsuccessfully tried to expose and destroy. By boldly turning the tables in this way, the Freemasons hoped to provide an effective smokescreen to cover up and obscure the true nature of their own activities. It would seem that their hopes were fulfilled, for even at the time of writing this, the wind still has not blown the smoke away. The fact that the Nuremberg Charter defined nearly all of the national institutions in Germany as being criminal for the purpose of the trials, as well as ensuring that the accused would be automatically found guilty of the conspiracy charge, not only effectively allowed the Freemasons to charge whoever they wished to charge, but also indirectly ensured that there would be very few witnesses for the defense. Indeed, whilst the judicial machinery for the trials was being prepared, large quantities of leaflets were distributed amongst the German people, requesting members of the what had been defined as criminal organizations to give themselves up, and asking any potential witnesses in the impending proceedings to step forward and identify themselves. Any member of one of the so-called criminal organizations who gave him or herself up could then be charged, if the prosecution thought it necessary, and all without any of the bother and expense of having to go out and find them. Any potential witness who was foolish enough to identify him or herself was often immediately arrested and charged with belonging to one of the criminal organizations, and accordingly with conspiracy to commit the other major crimes. If, however, the person in question agreed to act as a prosecution witness and not as a defense witness, then it could easily be arranged that in return the charges against him or her would be dropped. If it was not possible to eliminate a potential defense witness in this way, then he or she was often successfully deterred and discouraged from giving evidence by being beaten up. The few defense witnesses who survived re-screening process were, like the accused, kept imprisoned in solitary confinement in order to break them down and weaken their morale. No real distinction was ever made between the accused and the few defense witnesses who were able to give evidence at the trial. By the time the trials were underway, their value as witnesses and the weight of their testimony had been so effectively eroded and undermined by the treatment which they had received, that really their only function was to help create the impression that the accused were receiving a fair trial. This technique of inducing people to give themselves up voluntarily, and of persuading them to incriminate their colleagues in order to save their own skins, is strongly reminiscent of the techniques used by the medieval and Spanish Inquisitions to achieve exactly the same objects. The only major difference between them being that the Inquisitors were after Jews, Unitarian Christians, and Muslims, whilst the Nuremberg prosecutors were after fellow Kafirun. It may well be that the Nuremberg prosecutors were aware of and followed the example of the Inquisition, since the Inquisitors were then what the Freemasons of today are now. The Nuremberg prosecutors, who, in open disregard of the Kafir doctrine of the separation of powers, legislative, administrative, and judicial, were also both the legislators of the Charter and the judges of the accused, based their case largely on documentary evidence. The advantage of this approach was, and is, that you cannot cross-examine a piece of paper as to the truth of its contents, and a verbal denial alone of the truth of those contents, or of a particular interpretation of or construction, which has been placed upon Rose Conrens, is hardly ever sufficient to rebut the evidence apparently contained in re-document in question, especially if the judge is in fact already entirely in agreement with the prosecution case. The rules relating to documentary evidence, which usually apply to judicial proceedings in the Kafir courts of the West, and which give at least a limited guarantee of the possibility of being able to establish whether or not what is stated in any particular document is accurate, were for the purposes of Nuremberg trials waived completely. This meant that the Nuremberg prosecutors could conduct their case in a manner which normally, even by Kafir standards of normality, would have been condemned and brought to a halt for being biased, oppressive, and contrary to the laws of what the Kafir legal systems define as natural justice and international law. Indeed, it was even openly argued by the prosecution lawyers that since the accused's actions were breaches of international law, therefore they could not expect to enjoy the protection of international law, let alone to be tried in accordance with it. Basically, the prosecution lawyers were allowed to adduce whatever document they wanted in evidence, even if it contained second or third-hand hearsay, let alone first-hand hearsay, and even if the document was not an original but a copy. This meant that forged documents could also be introduced into the prosecution evidence without being effectively challenged by the defense. Even if a document was challenged as being of suspect origin, naturally, there would always be a sworn affidavit available, made by a sufficiently high-ranking legal expert, which stated that all documents were original documents and had been verified as such by whoever had found them. The Nuremberg prosecutors were given carte blanche by virtue of Articles 18 and 19 of the Charter. Under Article 18 of the Charter, the tribunal was to confine the trial to an expeditious hearing and to take strict measures to prevent any action which would cause unreasonable delay, and to rule out irrelevant issues and statements of any kind whatsoever. Article 19 of the Charter stated that the tribunal was not be bound by technical rules of evidence, and that it should adopt and apply to the greatest possible extent expeditious and non-technical procedure, and that it should admit any evidence which it deemed to have probative value. Anyone who has the time to read the record of the Nuremberg trials will see how time and again the tribunal used Article 18 to silence the defense, while allowing the prosecution to adduce whatever so-called evidence they wished by virtue of Article 19. Of course, the Charter also provided, by virtue of Article 3, that any attempt to question the validity of the tribunal's jurisdiction, or its right to try the accused in the first place, should be automatically dismissed without further ado. The Nuremberg prosecutors were not only able to adduce whatever piece of paper they wanted in evidence, but also often did so without first having served copies of these documents on the defense prior to their being produced. Furthermore, it sometimes happened that when an incriminating document's contents were worded in a language other than German, no translation was provided for the defense lawyers. Whenever this happened, therefore, it meant that the defense lawyers were forced to rely solely on the simultaneous translation service provided by IBM, which translated whatever was being said at the time into English, French, Russian, and German, usually about a sentence behind, and often inaccurately. Lane effect. This meant that the defense lawyers did not know what case they had to meet until the very last moment, which gave them very little time to prepare their case. Furthermore, the defense lawyers were not permitted to converse with the accused in the courtroom. They could only communicate by written note. This again limited what a defense lawyer could do when an unexpected point was raised by the prosecution. Since written communication was so much slower than the whispered word, when it came to trying to ascertain what any particular accused response was to the point in question, the tribunal also permitted the prosecution to adduce in evidence sworn affidavits of alleged prosecution witnesses who were, so it was said, unable to attend. This meant that the defense lawyers were unable to test the truth of the contents of these affidavits by cross-examining the people who were alleged to have made them in the witness box, and to ask them the questions which had purposely not been asked by the prosecutor who had prepared the affidavits. The tribunal permitted the production of such affidavits under Article 19, blandly stating that it would take into account the fact that such statements did not have as much probative value as they would have had if the person making them had been in the witness box and available for cross-examination, and that accordingly not so much weight would be attached to them. The truth of the matter is that the nature of the evidence was such that, although to a layman it must have seemed as if it was all being presented in accordance with sound judicial precept and established legal practice, in fact, it was not only heavily biased, but also the members of the tribunal could put whatever interpretation and whatever weight they wished on it. Indeed, the conclusions they were to draw had already been reached long before any of the evidence was formally presented for their consideration. By basing their case on documentary evidence, and by adducing rat evidence in the manner in which they were permitted to do so, the prosecution lawyers were able to say what they wanted without fear of being effectively challenged by the defense lawyers, and without having to rely on live witnesses. who might possibly have come out with evidence which was favorable to the accused. The prosecution lawyers were also helped by the fact that the accused had only been permitted to choose their legal representatives from a list of lawyers which had been prepared by the prosecutors, who no doubt had been sure to ensure that only Freemasons, or lawyers who would not put up too much of a fight or ask too many awkward questions, or lawyers who were unfamiliar with the mainly American and English judicial techniques and procedures which were being employed by the prosecutors, were included on that list. In effect, any lawyer who might possibly be aware of what the Freemasons were up to, and who would be prepared to oppose and expose their activities, was excluded from that list of eligible defense lawyers, and accordingly prevented from representing the accused.